except for licensing and some of the royalty collections, because BMI over here is a lot better at that kind of stuff. But it's all the way from hard science up to we do write-up publicity. We've done like wrestlers. They have to actually like their names are owned and their stories, and they have to buy them out if they want to be the same wrestler when they move to another place. So we've done it all. And if you're curious, well, you're probably not, but Billy Corgan of the Smashing Pumpkins actually is really into wrestling, and he was a mediator for one of our cases. So it's William Corgan the third when he's a mediator, though. And so I've been tasked with an IP overview today. I don't want to bore people, but it may because it's an IP overview of everything out there. We're doing an hour and a half. I've got about 45 slides. Normally, I would have more for an hour and a half. So I would like questions. Let's go off into weird places or specific questions if you have them. I'll show you here in a minute what all I'm going to talk about. I guess I should do a quick background. So I did do my PhD at Vanderbilt in cancer biology. I was in Richard Peake's lab. He's in gastroenterology. I think he's still the chair. And I met my wife there. She's in pediatric infectious disease. So if you got something that you need to know about that, come and find me. I'll get you to her. And we went up to Washington, D.C., and I did law school, and she postdoced at the NIH. And we wanted to come back to Nashville. And so I joined Patterson and haven't looked back since then. I did start my career off doing Hatch-Waxman litigation. So I have some knowledge if you ever have questions about how that all works and the regulatory schemes on that side of thing. Part of the reason I came down here was I wanted to do more variety than just keep generics off the market. So with that, hopefully we're going to click. There we go. So this is what I plan to talk about. We'll kind of do just the basics. Then we'll hit each of the main buckets of IP that we all kind of think about. There are a lot more than this. People don't know there's boat hull designs. There's a thing called mask works for the layers of circuits. There's right of publicity stuff. There's all kinds of other stuff that goes along with it. If you ever have questions about one of those specific pieces of IP, feel free to call me. And then I added a section at the end. I'm just going to hit a little bit on AI. Everybody loves to talk about it, but nobody has real answers. So I'm only going to talk about the things that we know for sure from the law, or as sure as we can so far, that affect mainly patents and copyright issues. And the copyright, I'm going to talk a little about art, but it's mainly in here because of the software aspects, because that is an option when it's not going to work for patentability for your software. All right, so let's go to the basics. So, how can IP affect your business? It's not just patents. It's more than an invention. And I have a lot of things just kind of listed here to get you thinking about it. But it's everything from the day you select your brand name till you exit your business that's going to matter for you. And people don't always consider that right at the beginning, but there are a few important things, especially surrounding your branding and your trade secrets, that you want to think about early on, even if patents are going to come a little bit later. So you can't protect an idea, but you can protect the implementation of an idea in a whole bunch of ways. And we already talked about those. And this is a Venn diagram that the other litigator at the firm put together that I think is fairly kind of accurate, showing the overlap. And we're going to look at this on an actual product in a second, just to see how all of these different domains can kind of interact with one another when you're talking about how am I going to protect a product. And this kind of is an overlay just showing what the actual tangible materials are, or even intangibles to the extent of know-how, where they fit kind of within these. And so happy to give this presentation out at the end if anybody wants to have it, because I don't want to just read to you this. You can look at it on your own time. But this is the example. There's a big fan base of Toyota Tacomas, the Taco Nation, that I've learned about. And we're going to look at, just as an easy example, all the different things you could think about. So just with patents here, these are some examples of some patents on the Tacoma. Then there are design patents. which is a whole different realm of patents that we'll talk about that only cover ornamental non-functional designs, supposedly. You can debate whether the style of a headlight is actually an ornamental non-functional design, but these automotive designers have been pretty good at stopping replacement parts from coming on the market by getting design patents on some of these little things. And we do, full disclosure, we do work for Bridgestone, but they have all sorts of interesting design patents on tire treads, which you can decide whether they're functional or not. And it depends, right, on what that design is actually doing. And so then on top of that, we have trademarks. You've got your make and your brand. There's probably more there. There's copyright. So the UI for the infotainment system, even the way the interface looks. And I'm going to talk about one interesting case of a patent, a design patent for I think it's a blood glucose meter that's being used just on the UI aspects of that. And then trade secrets. They have an eco fuel system. There's not really any patents out there about that. So we know they have this fuel system. I'm sure there's a lot of stuff that we don't know about how they program everything with respect to the engine and the clutch and all that sort of thing to save fuel. So let's talk about patents. We've got the famous light bulb because that's what everybody thinks about. So what do patents do? A patent is not a right to do anything except to exclude others from doing something. And so you always want to think about it that way. It doesn't, some might say there's no difference, but there is. I mean, you could get a patent on an illegal activity. That doesn't mean that you can go out and do it. Same is true for certain nuclear things and anything, as you know, that's regulated. But it does allow you to exclude third parties from making, using, or selling an invention. And I'm gonna call it an invention and talk about it more in terms of a product, but don't forget this covers processes and all sorts of different methods, and as you know, methods of treatment as well. So it's a time-limited monopoly in exchange for teaching the public how to make and use the invention. There's some conditions for patentability called enablement and written description, and those go with the idea of I'm teaching the public how to do it, and they have to be able to make it or use it based on my disclosure. And I'm not going to dive into all the specifics, but if people have questions about patent eligibility or the timeline of how we file patents or provisionals versus non-provisionals, please go ahead and ask. And I know I'm not going to look down and see them, but just interrupt me if we have questions that come up. And let's stop and talk about those. And so the time limitations are different for different types of patents, but generally you're going to see 20 years from the time that you file till the end. So there's three types that we're going to talk about today. Utility, that's what most of you know of as a patent. That's where you've got the long specification and description, and then the numbered paragraphs at the end. And those are the claims, and that's what matters in the patent. That's what tells people the space they have to stay out of. Your patent has to be novel and non-obvious. So novel means brand new, right? It means we can't go out and find that thing disclosed in one piece of paper or in one device out there. Non-obvious means it's not obvious to take some things that are already out in the public domain and put them together and arrive at your invention. All this is viewed from what's called the perspective of one of ordinary skill in the art. And it's all a bunch of lawyerly stuff that we get to do a big dance about when we go to court about what one of skill in the art would have thought at the time of the invention. So when we tell you it depends, we're not telling you that just to give you a hard time. It really depends on who your audience is, which judges you have, all that sort of thing. You may have heard of inter partes review that challenges patents at the patent office. There you have a panel of 3 judges, administrative judges that are specialized in that area of science. And people have called it the patent death squad because it's way easier to convince them that something's obvious than it is a jury that typically is not, you usually don't have people sitting that are beyond high school education most of the time. Maybe you have a couple people with a college education. So audience really depends on how these things stand up in the long run. And so you want to get good patent prosecution early so that you can withstand a jury or this panel of experts that may want to take apart your patent. And then it's important to remember with patents, there are statutory deadlines. In other words, there are laws that Congress put into effect that are then turned into rules by the Patent Office on how you have to meet deadlines. And essentially, the easiest way to think about it is in the US, you better apply within 1 year of disclosing it to the public. That's the easy way to think about it. There's a ton of nuances, and this grace period of 1 year is not consistent throughout the world. So depending on what your market is, it's something you want to think about early on. And it's something we do try to communicate when people are about to go present at a conference or something. If they don't want to file a provisional that day, you may be losing rights to certain countries immediately after that presentation. And there are even other countries that may not recognize that provisional in the United States. So you just need to know that depending on who you're directing your market to. For most of the markets that we typically see, you're going to get the 1 year. But I say that with caution because sometimes there are specific investors that expected to go somewhere and it turns out, oh, we can't go there because we disclosed in a talk, 6 months ahead, and now we can't go to that country.
Question.
Yeah.
Is it rare though if you file a provisional that a country is not going to recognize that?
It's
pretty. There's a few. I never knew that. Is there?
It'd be like
obscure countries.
Yes, and I only know this because there is a company, the area that does a lot of baby food stuff, and they go into everything. And some of these countries in like South America, like Chile and stuff like that, it's just totally different than what everyone else is doing. So that's why I note that. Like they do want to be there, and that's a place they want to file. I haven't had anyone really like with a university spin out that's ever been like, I need to be filed in Chile.
Gotcha. Okay.
But again, there are these orphan diseases that are in certain countries. So it's something like you want to have knowledgeable counsel to kind of warn you about this right at the beginning. Okay. Great question though. Design patents. So this is what I said was ornamental and non-functional features. So it has to have the same novelty and non-obviousness. These are a different length of time. They last 15 years, and there are no maintenance fees that you have to pay on the back end of these. And as I noted, you can cover graphical user interface features. Packaging is another thing, mainly around electronics. Also, like I mentioned with the Tacoma, preventing aftermarket competitors from making or selling replacement parts or counterfeit goods. One of the interesting places that we've thought a little bit about design patents that's starting to come about is within 3D printing. So a more specific example could be, say you're 3D printing and you have to, or it confers an advantage onto whatever medical device you're making. You may come up with some aspect within that 3D printing where we can actually protect, like maybe it's a scaffold or something like that you need to have that you find out is better. You can protect that with a design patent as well as possibly a utility patent, or maybe some of each. And in fact, you can file continuations off of patents. Like you can file a design patent as a continuation off a utility patent. So we do see that sometimes with Bridgestone in the tire area, the way that they'll build out their portfolios. So this was the use case I was going to put up. I thought this one was interesting because I was like, I'm going to search design patents within pharma because I know they're really big on their drug device combos. And I was wondering, do they do device patents as well? This is one from Eli Lilly. It's small there, but it's display screen with an animated graphical user interface. So that keeps it really broad. And what you'll see is in the design patent, instead of a utility, all the claim is the ornamental design for the display screen with animated graphical user interface as shown and described. And that's basically the same claim you always get. And then that means you're just claiming these figures. Okay, so these are all the figures from their patent. This is their entire design. But you can see how that could have, that could be problematic. And the damages are really high for these. It's really weird. It's a weird regime, but we like hybrid approaches when there's an opportunity. We have gone so far as one since it's in the public domain, I can mention it. one thing we filed design patents on was we had a cannabis company that it was an interesting invention. There's actually a PhD for cannabis science at UC. It's not Berkeley. I can't remember which one it is. One of them. And this scientist had discovered how to extract cannabinoids into water-based, which had been a problem. Now I know we have all these sodas and things you can buy out, but for years, people couldn't get it in drinks. And that was the goal, was how do I do this? It turned out there was a really odd seaweed out there. And if you mixed it together and put it on a belly dancer and you let it would suck up all the good stuff, all the THC, all the little different things, and then you could form that in molds. And one of the things this company was doing, it was making flakes of this infused seaweed that they then would flavor. And we applied for design patents on the actual like flakes, and then also on some of the molds that they were going to use to put that in. So there's like a whole lot of stuff that if you're not being creative, you don't think about that can really build a barrier. Now, a lot of this is for once you got the money to spend, but it's something to always be thinking about. And these design patents are really cheap, relatively speaking, to a utility patent. There's basically no prosecution other than if they don't like your figures enough, you may have to deal with it. So it's really paying a patent draftsman to make the figures. You can do photographs as well. So for those flakes, we actually hired a group that did one of those like 360-degree photo things. So we could pick the best shots of it to apply for the patent. So here you go. I mean, and the test for this is, would an ordinary observer think that your product looks like that design patent? So it's a pretty, an ordinary observer for this type of a product would be anybody going out and buying a glucose meter. So that's a pretty low standard to whether they would think it infringes or not. It's a lot harder to argue, and it's much more subjective than a utility patent. So a lot of times when people get sued with design patents, it's, as a lawyer, you're like, oh, this is much worse because it's so vague. I can't tell you what the outcome is going to be. I can't promise you we have a position that's going to work because the jury is going to decide, would an ordinary observer think that they're the same.
Just noticing it's a 2021 filing. Can't help but think that glucose meters have been around for a while in this configuration. So I was just wondering about design and prior art.
So they do a little prior art searching, the examiners do. It's a little different, and I don't really know what their database looks like for that. So, I mean, yeah, you might be able to go out and find a great piece of prior art and attack this. And what's weird though, like in addition, the way they've done this series of how you insert and take out, I bet that's part of what they used to argue why they were like different from whatever was found. And this isn't in here, but there's a really interesting aspect to that you can put hashed lines, or you put dashed lines and eliminate different pieces of it. You can get design, like you could get a design patent just on that button arrangement if you want it, or what have you. So there's all these ways to kind of break these down and do things with them. And I would say 9 times out of 10, when people come to me, they've never heard of this, or they've like heard about it, but they don't really know how you would ever use it and haven't thought about it. Well, we'll talk about it for sure.
Does this have the same rules on the disclosure? So if they already had this thing out there and it was in the public domain?
Yes.
Okay.
So it has to be novel and non-obvious as well. So yeah, I mean, you can bring prior art and like invalidate these patents. It's just, they're so vague and it's so hard to know whether you'll invalidate it, that's why these are just, they just create gridlock, right? And more litigation. So they're a nice threat when you have an extra one. Like there's all sorts of things. One of the ones we did that was really interesting was people who like to run races, you get a medal every time you run a race. And there are all these cool people on Etsy that make these cool displays for that. Well, some guy had gone out and gotten a design patent on like putting a hook in a thing to hang medals on. And like, he was really causing problems because he was having people's stuff taken down off of Etsy. Because like these design patents, to be honest, if you're competing on Amazon or something, it's way easier to get them to take something down with a design patent. Because with a utility patent, a lot of times they want a judgment of what infringes, because they're like, we're not patent lawyers, we don't know. But for these, they're like, oh, we can look at it and see that it is the same thing. So a lot of times we recommend to people that are going to sell things on Amazon, I'm like, let's just get you a design patent, because that's your quickest way to like make sure you can ask for takedowns. I had a question.
Yeah, so let's say you can divine some kind of utility out of the design patent. I'm thinking like street construction, that is a design patent.
Mhm.
And you find utility subsequently, can that happen? Is that protected?
So you just have to be careful about how you talk about functionality when with the patent office and like in any public record on that. You'd be a lot better served to go from like, I have this utility patent and I'm going to kind of come off of that with a design that's in there. It would look a little, I don't know, it's that lawyer thing. It depends. It really depends on how much functionality is in that design. But you're targeting something. As soon as you said that, it made me think, I bet they have design patents on IUDs, right? And those shapes are functional to some extent, but I guarantee it. They might even have, you can get different protection on, they may have trade dress on the color of the IUD, right? Like there's all these things that you could probably do that people don't think about that I'm sure pharma has thought about. Yeah. 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 So I'd need a specific use case, and then I could like list you 2 columns about why I think it'll work or why I think it wouldn't. But it's always worth considering. And like I said, these can be so cheap that depending on where you are in your stage and how much money you have to spend, it's worth just taking a stab at it a lot of times. They just don't cost near the amount to prepare and to prosecute. So it's something I think everyone should be thinking about. So going back to utility patents, I must have to rearrange the order. This is a new presentation for me. But this is what we think of novel structures or arrangements of conventional elements that are new. Usually the way we like to think about it is when someone comes in and we're like, how are we going to draft this up? We want to know, what is the technical improvement that you've made to the underlying technology, or what is the problem that you solved? And then a lot of times it's great if we can have a discussion about, well, how did other people either solve that problem before or try to solve that problem, and why are you different from their solution? But when you're thinking about your patent and what's going to actually be in the claims at the end, that's what you want to think about capturing. And I'm just going to warn people that are on here who may be hands-off in their patent approach. Particularly, this can happen sometimes at universities and other institutions where it's just kind of handed off. You want to be in there looking at the claims and making sure that's what you invented, that they're hitting on, it's not a correct way to talk about it in court, but what is that point of novelty? I don't really like to talk about it that way because we're always going to say, well, it's all the limitations in the claim put together, right? But when you're drafting it, the most important thing is that 1 or 2 points of novelty get captured in those claims. And if you've got 2, maybe you have 2 different, and we can talk about independent and dependent claims, but you have 2 different independent claims for each point of novelty. And then maybe you ended up combining those 2 points of novelty in a longer claim that's more narrow. And then, this is partly in there because we want to think about all the categories that might come up, but we've got chemical formulations, and then it's easy to think about this in the pharma context. So you got your active ingredient, right? That's the first foundational patent that pharma will do. And then what comes after that, it's their formulation, composition. So if it's a quick release or a slow release, or it has a certain way that they've done the coating on the outside so that it, withstands the stomach lining, or if they've done something where you're going to take it, orally or buccally, that sort of thing. Then the method of treatment tends to be the last thing you see. And there's always this kind of 3 layers of patents in pharma that you see come out. And I think generally that applies in the device world as well, if you can do it and think about it. Although active ingredient might not be so much. So it kind of depends on your device. If your device has a new like composition within it, maybe that's the first place you go, then the way it's all packaged in the device, and then the method of using that device. And then you may also have methods of manufacturing, because you may, like I said, with 3D printing or something, there may be specific ways you're doing it that you want in there. Then there's articles of manufacture themselves, machinery and systems. And we're going to talk a little bit about software, some more ways to think about it. And I mentioned this already because I always get ahead of myself. How did you solve the problem? Now, when it comes to software and algorithms, this is a messy area. It swings back and forth like a pendulum, what we allow to be patented and what we don't in this country. And we've watched it as lawyers over the past couple decades go back and forth. The thing to think about here is, can you identify, and do you want to, in your patent, identify a specific algorithm that gives you a tangible result or a physical transformation? So what you don't want is a functional, when you're reading the claim at the end of the patent, you don't want something that's functional or results oriented. So like you'll see it within a claim, but you don't want to just say like it's a software that does this, that, you know, that can separate, you know, well, I don't know what a good example is. Results oriented is how we say it. Like it can't target just the result. You've got to say, how did I get to the result? And that has to be a technical solution. And so a lot of people will just say, I got this software and it gives me this. That doesn't work. And it did for a time. And now we're invalidating every one of those patents. And so it helps if you have questions about that. If you bring me a specific like concept, then I can talk to you about it, or I can pull out an example of things that we've been able to invalidate. But it's got to be something more than just, I made a software, and so any software that can achieve this result infringes my software. And so you do, when you have something really interesting in terms of an algorithm, it is worthwhile going after a utility patent. You want to balance that with how much you're going to disclose. The only other real way to protect it besides a trade secret, and I'll talk about that too, is copyright. But with copyright, as we'll talk about, that's only going to protect that version of the code that you have. So there's so many ways to implement code. It's easy for somebody to design around that. With respect to software copyright, it's more used to prevent counterfeiting than anything else. And the greatest cases we see that in is where the coders have dropped little mistakes in or things that people don't notice, and then you find it residing on somebody else's product or on their server, and you're like, well, they put that in there intentionally, so we know that you stole it. So it's important to think about copyright for your software, but it's not going to protect anything other than that specific coding implementation. And I'm getting ahead of myself again, but so some of the areas where we want to see specific algorithms, and when I say algorithm, it's not the mathematical, it could be, but it usually is a very specific flow chart that explains how you're doing it. And then that may be dependent on a few formulas that are disclosed within the patent. But we're really seeing this and the difficulty in writing claims for AI modeling, of course, because a lot of people, you don't even know how the model is actually working. So that can become very difficult. Control systems, with computers, it's got to be an improvement in the computer's operation, not just implementing something on a computer. If you just speed something up because you implement it on a computer, that's not enough, right? And it shouldn't be in this day and age. It might have been in the 70s and 80s, but it's not anymore. Yeah.
The different levels of evidence that you need to show in the patent for those types of, because deterministic where you know you're getting a result, it's kind of what you said, other software can do it versus generative. If you're pulling more data, I was just curious the type of data that you need.
So when you say that, are you talking about if I wanted to patent a generative AI model itself? Yeah, I don't. So I wish Gary Montel was in here. He sits next to me. This is his area of expertise. So I can't say that I've seen a lot of, there are patents on aspects of generative AI models that sit out there. you do have to describe in a flow chart kind of how the recursive learning, I'll call it that, is occurring. Like, how is it making those changes as it learns? And we have certainly gotten patents on that. Whether they'll hold up in 10 years when we're ready to go sue somebody, I don't know. But the patent office thought it was enough, and they're being pretty hard on that. So you actually don't have to have any working examples to get a patent. It's a good idea. You can have what's all called prophetic examples that are kind of like, this is what we think is happening, or this is what would happen. As long as you've really disclosed, that kind of stepwise how it's doing the learning. Yeah. And so usually it's going to be like one specific kind of module that you've come up with in there, and that's where you're directing your patent. And so that's where this question of how are you doing it differently than other people that's why you got to start there. And if you can't articulate to us how it's doing it differently, then Gary's pretty good, but it's going to be really difficult to articulate in the patent how that's working. And then there's image recognition and classification techniques. And so these are some that we see that kind of sit on the balance, because it's like you're analyzing imagery and then saying, does it have something or does it not? If you're not really doing something transformative, if you're just collecting information, that tends to not be patentable. So a lot of times it's good to see these kind of claims combined in a method of treatment, that like you're going to act on this by then giving a certain dosage, or you're going to act on this by, selecting a responsive patient pool and then treating that patient pool or something like that. I do have some basic steps. So the basic steps for filing a utility patent is identify your invention, including any software implemented methods. The deadline is 1 year from public disclosure. I gave the caveat. So you can file different applications. You can file a provisional, a non-provisional, and an international, or what most people call a PCT. It stands for Patent Cooperation Treaty. That's why it has that name. So we have a treaty to try and harmonize all the patent laws as best as possible and all the filing rules to make it easier. And so most countries that you would file in would be a member of the Patent Cooperation Treaty. So a provisional is what it sounds like. It doesn't get examined. You don't actually, we throw a generic claim at the end, but you're not going to draft claims. And that's how it saves money, because what should be happening is about half of the work that goes into drafting a patent application is getting the claims perfected. And if you see the balance of your practitioner's time going into the background and the description, you may want to look at the claims a little harder, because that's, I won't say it's always that much, but it should be a significant portion of the time, because that's when the rubber meets the road, that's what the court looks at. So provisional, it gives you, at least in the US and with most PCT countries, this 1 year grace period to convert it. You don't need formal drawings. That's another place that you save money. And if you're running off to, like, you realize, oh no, I'm going to disclose something tomorrow, we can slap a cover sheet on it and, just file your PowerPoint just in case if you need that. So we're happy to do that. It's a pretty minimal cost. Provisional filing fees are already low, but I'm going to warn you, the patent office is coming for your money, because their latest fee increases, they're one of the few self-sustaining agencies within the government. And so we're all like aghast that they have just stopped the hiring of all the new examiners they were going to do. They've retracted the offers, and then they're going to try and make them all come into the office, which isn't going to work. But they make enough money to pay for themselves and then some. So they're not, they're a black line in the government budget. And they intend to stay that way with the way they're increasing fees. So, we're even cognizant of, I think we sent something out at the end of last year to a few of our clients where we knew, like, hey, if you want to do X and Y, it's going to be cheaper if we do it this month than if we do it in February when your response is due. So that's the provisional. It's very simple and it can kind of range. And the nice thing about that is, at least for us, we're happy, and even on the non-provisionals, to let you do the heavy lifting, and we can get the final little formalities taken care of for you. And then, of course, when you come with us, we have a docketing system, so we're not going to miss any deadlines for you. And that's another added value that you're getting out of that. For the non-provisional, you know, a lot of times we recommend people just go for it. I know it depends on your stage, right? And for most people that are probably going to be watching this, they are going to want a provisional. They're going to want a year to get more data to develop more things. But we have some people come to us and we're like, there's no point. You know, it's going to cost you more in the long run to do both. It just is. That's just the way it's going to be because you're going to want to change things and add things. And, you know, the non-provisional is ready to go. And we got a large backlog at the patent office. I think I heard 85,000, which is actually way better than it used to be. It used to be in the hundreds of thousands. So you may want to go straight there. And then the international or PCT application, you can do that and then enter any of the national stages, as we call it. So you can do that one first, and then 18 months later, you can file your non-provisional in the U.S. Patent Office and in any of the other places you choose. This is where the price goes up. If you're not this far along, when you enter the quote national stage, so you file this international application, but then you got to go to all the patent offices within 18 months that you want to do. And there is one in Europe. So there is a European patent office that covers a fair amount of countries. But we're talking Europe is one, Australia is one, Japan is one, a very expensive one for translation. Korea, another one that's expensive for translation. So you really, when you're thinking in your long-term timeline, you really have to evaluate your market and be thinking 30 months from when I file this provisional, how much money do I need to have to go into all the countries that I need to be in for what I think investors and or a purchaser is looking for.
You just said 30 months there. So that's the provisional it's 12 months until you have to file the non-provisional.
Or the PCT.
Or the PCT. And then from that time, you have 18 months.
If it's a PCT, you have 18 months to enter the national stage.
If after a year on the provisional, you only file in the US, do you lose the right to the other countries? So at 12 months, you have to file the PCT.
Yes.
If you file just a non-provisional, so just in the US, like on day one, have you lost all your rights to all the other countries?
Yes.
Okay.
Yeah.
So the key is if you want to do international and you need some time, it's best to file the provisional. And then in a year,
I think so.
You have to, but then in a year, you have to file the PCT.
You file the PCT and then you get 18 more months before you're going to have to pay all those patent offices. Now, there is an option that people do sometimes, and that is to go ahead and at the same time they file the PCT, they file the non-provisional. And that's because they're going to seek one of these expedited type examinations. And I'd have to look and see how much, I may be speaking out of turn because I mainly litigate. There is this patent prosecution highway, and I got to make sure it's still available. But that is one where when a patent office that is considered I guess, of better quality, like the US, allows it, if you have there's requirements on what the claims have to look like in the other office, but they'll look at that prosecution and basically put it through. And that's, you're familiar with that, right?
Yes, a couple examples. A lot of times, if you're looking to raise money, you're not going to get any until you have it back. So in that case, you wouldn't bother with provisional.
Right.
Straight in because your clock's not raising. We just did one under track one, which is
another way, yeah.
Which gives you your first office action within the year. And you pay extra money for that. So
that's one of the ways they're trying to raise more money for the patent office. Yeah.
So that one was, we wanted to get that as soon as possible, try and raise money. So no provisional, straight to track one.
Track one is like a fast pass at Disney World.
Did you file the PCT on that? And did you have to file PCT?
PCT, track one, national cities, multiple countries, it was expensive.
But when you did the PCT, did you just do the non-provisional in the US to get the track one and then wait on the other countries, or did you?
So track one is different than patent prosecution highway. That's just that's a line skipper at the US patent office for money. Yeah.
Otherwise, we will get to.
And there's a limitation on the number of claims and the number of independent claims to be eligible for that. And a lot of these are different pilot programs, so they come on and off. And so if you hear about one from somebody, you got to check and make sure it's still available. Because they're always, they're trying to innovate at the patent office too, to get more money.
Something that says patent pending, Is that usually what that might?
No, patent pending just means I photocopy the back of the crayon.
Yeah.
and mail it to the back.
Yeah, if you want to be patent pending, we can go file you a provisional right now, and you're patent
We
pending.
can skip
So
it.
that's like, okay.
Yeah, we can grab a crayon and a cocktail napkin and file.
I mean, there are people that just want to file a new provisional every year to say it, which I think it's not a particularly useful thing, because now the provisional doesn't see the light of day, right? So you haven't revealed it, but if someone else has come up with your idea in that time frame, you're out of luck when you finally go to convert to non-provisional and you filed a series of provisionals, because you can't claim priority all the way back. You can only claim priority for that 12-month period ahead. But everybody has a different business model, and if they want me to file a provisional over and over again, I'm happy to do it if that works for their model.
So for the one piece, so that just gets them to look at it within 12 months. What's the current average?
So that depends on what's called the
6 years.
yeah. So the question, I should be saying some of these back to make sure they get on here, because it's my microphone. The question was, what was the question? Whether sorry, what was the question? The average time, that's right. I was going to say art unit. I had that in my head. So what is the average time to the patent office picking it up? So it varies by art unit. And so it's very specific. These examiners only examine specific things. One of my good buddies from my fraternity, like, he only did contraceptives for like the 4 years he was at the patent office. There's an optical disk drive unit. And those averages are different for each unit. So as soon as we know what art unit you're in, we have a resource we can look in and tell you. But it is longer for life sciences stuff. And obviously, the more complicated that stuff is, the longer it tends to be. 6 years might be a little longer than I would think to a first office action. That sounds more like an average to getting allowance. I would say 3.5 to 4 is in the life science industry is probably accurate. But again, it's very specific to art units and how fast they turn it over.
So the last one I was involved in that was regular was 2.5 years. First,
2.5 years for those is what we've heard from an experience. Yeah. 6 is probably, yeah. I mean, that's all about what kind of fight are you having and how many, you can either file what's called a continuation to keep it going, or you can file a request for continued examination. They're really not that different, and I won't go into it. It's a nuanced patent attorney thing, but that may happen multiple times. I have one patent that we're litigating that took 11 years. And it had to go through an appeal to the Patent Trial and Appeal Board that finally overturned the examiner and was like, this is not obvious. Like, you're crazy. Allow the patent. And so you have to make a decision. If you're just at a roadblock, you may file this appeal. It's expensive. I think just filing it, I think you have to pay, it may be a $20,000 fee. It's a lot. But sometimes if it's that important, that's what you got to do. Because that gets you a better board of these experts who will say, no, that guy doesn't know anything.
that's actually we have final office action put out for being, obviousness, and file that, and then the SBI supervisory patent examiner. It's like, this guy's nuts.
Yeah.
We're gonna get you.
Yeah, so sometimes you file that appeal, and the supervisory patent examiner, the SPE, they will come in because they're going to have to write a brief against your legal brief, and they may come in and look at it and be like, no, we do not want to waste time on this brief. Lower down guy, you're wrong. Like, we're going to give up. And so sometimes that's what it takes to get them to give in. Other times you got to go all the way to the board making a decision, and then you can decide whether you want an oral hearing they'll give you 45 minutes to an hour to go up to the office and argue. You can do a lot of that remotely now, but so yeah, there's a lot. And I mean, if you don't like that, you can appeal to the Eastern District of Virginia as well and go to a court and just keep appealing. But I would suggest that if you don't win at the Patent Trial and Appeal Board, you're cooked at that point. But it turns around a lot there.
Like a certain point that would be worthwhile, right? If you've got to wait 11 years, well, that's more than half of your.
Yeah. Yes, yes. And I didn't prosecute that patent, but I probably would have pulled the appeal trigger about 6, 7 years in instead of year 10. But there were other problems with that patent. So well, since I'm talking about that, that raises something. If you don't like your competitor's patents, you can anonymously submit prior art, and then the examiner will look at that. And so if you think you have something really good, I don't always recommend doing it this way, because once you submit it, like, you don't get to say anything else about it. But that was an issue in that prosecution, was every time an allowance would come, anonymous art would arrive. And then a new rejection would happen, and to issue is you start getting anonymous art from all over the place. And they'll mail it to the attorney as well. And then once you have it, if it's material to patentability, you have a duty of candor, and you have to file. So then you'll have to pull it out of allowance and file what's called an information disclosure statement, where you list that art on there, and then you may get a rejection based on that art. You can't pre-argue it when you submit it. You have to wait for the rejection. So if you don't like your competitor patents, that's one way to do it. I'm very interested in, I guess I won't get into it, but there is a guy in town that has a whole presentation on AI generated prior art. And the idea of using AI, once you're in your space, to just create prior art and put it out on the internet to try and block anybody else from like filling in the rest of the space. And then another interesting thing that is utilized by certain companies is crowdsourced prior art. So I have a friend that's the general counsel at Unified Patents, and they're like they're called a defensive aggregator. And so you subscribe to zones of protection with them, and you pay a monthly fee based on the size of your company in certain areas, and they buy up all the patents in that area and keep people from getting sued. And if people get sued, they'll go and try to invalidate those patents. But they do these contests. And so they're like, if you identify a piece of prior art that we use in a patent challenge, we'll pay you $5,000. You can imagine the amount of searching that is happening in India when one of those contests goes up to win 5,000 US dollars, right? Like and so they have done really well in validating patents through crowdsourcing. So there's all kinds of stuff out here. Really far afield, huh? And I have 30 minutes. Oh my gosh, I'm not hard through anything. All right. We're good. We're still on patents, so I'm going to go through quickly. I wanted to give a regulatory note. I found this interesting because these drug device combos were being used to keep things like this, like albuterol inhalers and different things, to cause people to have to go through the whole ANDA litigation. It's finally been ruled you can't do a device. It has to be an active ingredient, a composition or formulation, or an approved method of use. So the Federal Circuit, and they hear all patent appeals in the court system, they're right below the Supreme Court. So if you hear people say Federal Circuit, they're probably going to talk about some patent stuff. They ordered the delisting of a design patent for Teva's albuterol inhaler that they were listing in the Orange Book. So just something to think about. You can't prevent an at-risk launch anymore by listing a device. Now, that doesn't mean that a device is not valuable, because it may be that it's hard to have safety and efficacy if you don't have that design of that device. So it still may be in some ways blocking to a generic that might want to come on the market because they can't achieve the safety and efficacy, or they have to spend a lot inventing around your device delivery system. Patent, yeah.
That example was the copper products where you're using the device to deliver the drug. So the new one I see a lot of is companion diagnostics. And so you're defining the biomarker population for the drug, and then the generic comes, but they don't have access to that companion diagnostic. So that's been interesting.
Yeah, and they're writing those into methods of use. I did some of that when in a previous prosecution era of my phase. And those have not been challenged yet. They should be listable based on the last opinion because they're a method of use. There may come a point in time though, and again, a lot of this has to do, I think, with AI, because it's going to figure these things out so quickly that we say we're not going to allow that to be listed anymore. But it may take Congress to change it. I don't know if a court was ready to do that based on this latest ruling. Because they kind of said, if it's a method of use, you're good to go. Patent marking, just to know this, it's especially important if you end up licensing. You need to put on your device, if you can, or on the packaging, if you can't put it on the device, the patent number when you have an issued patent that covers that product. Now, you can do virtual marking where you list a website and then and that's what everybody does now. Then you can change the patents. But that website can't just be, here's a list of patents. It has to be for this device, it practices these patents. For this device, it practices these. And this is serious business because you can cut off all your eligibility for damages if you don't do this right. And people don't think about this. So if you don't demand, if you're going to license this or you're going to have it distributed and someone else is making it and you don't demand that they and require in your contract proper marking, they can blow up your entire eligibility for damages. And it has happened a lot. And I just got done with a litigation where they messed up bad on that aspect. And so we were able to really.
Pharmaceuticals too.
It's for everything. Yeah. So, I mean, for pharma, you wouldn't stamp it on the pill. It'd be in the labeling. And it doesn't apply for processes. So you don't have to, if it's a method of use, you wouldn't have to list that patent. If you had a method of manufacture, you wouldn't have to list that. It's only for things that claim the article or the composition or so, whatever. One thing people don't think about is plant patents. I brought this up because we do have a lot of ag people that are doing some cool things in Tennessee. I'll let you look at this list, but there's plant patents, and that's for asexually reproducing a distinct and new variety of plant. You have to be able to use one of these methods of asexual reproduction for that, and you have to deposit specimens of that. There's also a different thing. I told you there's a lot of weird stuff out there. The Plant Variety Protection Certificate. This is from the USDA, not from the Patent Office. Oops. And so this is for new, distinct, uniform, and stable plant varieties that include sexually reproduced varieties and some tuber propagated varieties. And that gets you 20 years or 25 for trees and vines. I don't know why. To exclude people from selling, marketing, or distributing, and from using it for propagation. It's novel, distinct, uniform, and stable are the requirements for that. There are research and farmers exemptions. So this is a little different than what you've seen about Roundup. That's utility patents. It's a different thing. So for this, farmers can take the seed and propagate it. But that's it. You can't propagate it and then go sell it. But they're interesting, and you'd be surprised at how many of your sweet potatoes are protected by one of those two regimes. LSU does a ton of sweet potato work. It's really weird. And I've seen lawsuits where they sue big farms out in California because they're not paying royalties on that variety. Okay, and then inventorship. I'm not going to get deep into this, but what I'll say about it is, all right, keeping an eye here. It's conception. Conception, conception, conception. You're an inventor if you conceive of something that is in the claim. Now, there's some exceptions if it's like a well-known thing or whatever, but it doesn't matter if you reduce to practice. And what am I talking about reduced to practice? Reduced to practice means I made it in the lab. But if someone else thought of it and told you to go make it in the lab, you're not an inventor if you made it in the lab. And this is important because universities do not understand how to do this correctly. And then it leads to a bunch of royalty fights, and it's dependent on the claims. So you need to reevaluate it when you get your final claim set in. Is everybody listed on here? Did they conceive of something that's in one of these claims? And I mean, this is really important. I've litigated inventorship cases. They're really fun to litigate because most of the time, all our stuff is down on paper, but these are the ones where everybody's arguing about who did what and everybody wants the credit for it and all that. It is conception. Once you know that you've thought of every claim, every feature of the claim subject matter, and you probably could reduce it to practice, you're there. If you still need to do experimentation, you may be an inventor, and then there may be more inventors if anything has changed due to the experimentation, if some new thing was conceived to improve it. All right, so that's that. We got through one regime. Trade secrets. I love trade secrets. They're so much fun because there's so much weird stuff that happens in these cases. And usually there's some bad actor that did something and you never know how they got it or whatever. And you never probably will know, but you get to fight about it. So a trade secret is anything. That's the easiest way to think about it. But it's really anything that has value because other people don't know about it, right? I did not write this, but I like this. It's the most broad and ephemeral form of intellectual property. There's no registration system. It's protected by contracts and business practices. And think about formulas, recipes, know-how, and I drop it into two buckets. It's like R&D tech, and then customer, business, vendor information, all that stuff. Your compilations of all your vendors, particular ingredients that you buy, that sort of stuff. The classic one that I always talk about because I'm from Kentucky. In fact, I'm now a Kentucky Colonel. So like Colonel Sanders, who came up with the 11 herbs and spices, I hope that I can have a good trade secret like that. But what's funny about that, I know that you can go online and get something that tastes close, but they actually have 6 of the spices mixed by McCormick, five of the spices mixed by another company, and they send 2 packets into the KFC, and then they put them together. And supposedly nobody knows all of it at once unless certain people are on a plane together, which is probably crap. But anyway, I have lots of fun trade secret stuff, but I won't talk about it. I'll just talk about what you need to know. So I said not known or readily ascertainable to others. So if it would be easy to find it from the public domain, it doesn't count. The biggest thing is you need to be able to identify it. So what happens is people file a trade secret case and they say, they took all my stuff. It's all my design stuff. No. Like, it's going to come down to a few documents. The best example I can think of is there was a fight between Uber and Waymo, and this dude Anthony Lewandowski, put 100,000 documents on a hard drive before he left Google to go come up with his competing thing. But it was 14 documents were actually the trade secrets. That was the LiDAR technology that mattered. And so I have a whole nother talk on this. If you ever want to hear about how to kind of like implement a scalable trade secrets program, I'll talk to you about that. Happy to give you that presentation. But what you need to understand is when you're thinking about your trade secrets, it's like, let's write them down in a specific format. Like if you can't write it down and tell me what it is, then that's not what we're talking about here. And usually it's going to be stuff that's in your lab notebooks, SOPs. Those are the real like juicy trade secrets. And the biggest thing to know is you have to protect it from disclosure using reasonable measures. They're sliding. So Microsoft, because it's big, has to do a lot more than a 2-person company does. And what I can tell you is, without going into it, statistically, non-disclosure agreements are like the most valuable thing that you can use, but you need to do them with everybody and be consistent. Because if you start to say, I have a policy of doing this, and then you don't follow it, now you're being unreasonable. So these slides are things that you can look at later to think about how to classify trade secrets. And just a note, in your non-disclosure agreements, it's good to put this DTSA, that's the Defend Trade Secret Act whistleblower clause. It just says that like if you're going to be a whistleblower, like we're not coming after you. And the reason is for trade secrets, if it's willful, you can get triple damages. You are not, we haven't really seen the effect of this, but supposedly if you don't include this in an agreement with the person you accuse of stealing the information, you can't get the triple damages. I've never seen it happen. I've been saying it since 2016. Put this in your contract, put it in your contract. We don't know for sure if anyone can ever win, maybe because everybody started putting it in their contract. I don't know. Here I gave some quick litigation examples I found for some bio stuff. The natural biologics one was really interesting. It was for producing these bulk natural conjugated estrogens for Premarin, and there was no natural produced one before. And they got to a Wyeth chemist and got him to like spill all the beans, even though he didn't have like it wasn't clear there was even an NDA. The judge is just like, he should have known he wasn't supposed to be talking about that. And so they got all the way to commercialization, and the court was like, you're not allowed to, ever. You can't sell this. This BioPoint versus Catapult, that was a consulting services to pharma and biotech. So this was business information. And what happened was basically some employees left, and all of a sudden they had secured these contracts with people that they were in prior discussions with the other company. So that one got a temporary restraining order. That's real recent. Or maybe that one's settled. So I don't know. We don't really know. And then this Alifax v. Alcor Scientific. This was for a blood analyzer. And I mentioned this one because 6.5 million jury award, although we're awaiting a new trial on damages. All right. Got about, I'm supposed to stop at 5. Is that right? 10 minutes per each regime. All right, trademarks. So this is going to be an important one to think about early on. You got to have a brand. What does a trademark do? It's a word, name, symbol, or design that you use in commerce, and this is what it's for, okay? It's for identifying the source or origin of goods or services. So putting a slogan on a t-shirt isn't a trademark unless you know where that came from. So if it says just do it, you're like, oh, I know that's Nike. That makes it a trademark. But if I just slap a new phrase on a t-shirt, that's not a trademark because I don't know where it came from, some meme off the internet like that. Now, people will go and try to protect this stuff, and sometimes they get marks on it, but it's not going to really work out. So always think about it as identifying the origin of the goods or services. I don't think we'll have a problem in bio with that. What we are going to have a problem with is the spectrum of trademarks, which I'll talk about here. There are generic marks. Think Xerox. That meant nothing when they came out with it. Even Kleenex. It's got clean in it, so maybe it's descriptive, but it didn't really tell you what it was. These are the best marks. Google. I mean, what the heck did that mean, right? They're the best marks. They're the strongest marks. And I know everybody in this industry wants to put something in their mark that describes what it does. But you're better off in the long run doing something crazy and that no one's ever heard of as your mark. Even Apple for computers is not descriptive at all, right? It has nothing to do with computers. I'm sure there's a story behind it that maybe it does. So then the next is this, oh, I'm going the wrong way. I'm saying generic. Fanciful. Sorry, that's fanciful and arbitrary. We're starting here. These are the strongest. Suggestive marks, those are not bad for this industry. Descriptive is where you start to have problems because if it gets too generic, so I've got a case right now I'm dealing with, 24-hour plumber. It's the most descriptive mark I've ever heard, right? It's fine, but how much can and I think it's a great name, if you want to be that, but you can't really do much to stop other people from being 24-hour plumber. Okay. And so I apologize for going the wrong way as I was saying that. But yeah, so think about this early. And then the other thing is, so this kind of explains what I'm saying. Part of this is too, if you're too generic and even too descriptive, you're going to have problems getting the registration. You're going to spend money on the prosecution. They're going to make you disclaim certain words out of the phrase, which means your whole phrase might not count. So I can't remember when I saw that 24-hour plumber mark, I think they had to disclaim plumber out of it. And then it's like, what does your mark even do now? So it's really important to think about this early. Yeah, here's an example, e-ticket. That's not going to work. And I had all this ready to go. I should have thought more about what was coming. Starbucks, there's another good one. And so the other thing to think about that is too, you need to search and make sure you're not going to invade other people's province as well. And if you have something that's more generic or descriptive, you are more likely to be like other people out there. Now, there's 3 types of trademarks to know about. There's the actual registered trademark. That's when you can put the circle R. That's when you have a registration from the United States Patent and Trademark Office that has been granted. Now, you can have an unregistered trademark. That could just be, you just use it and you put your little TM next to it, or it could still be pending at the patent office. It could be only registered with the state. I don't really recommend the state marks. That's more for people who are doing something very regional and want to not spend money. They don't get examined. They don't really mean a lot. It's enough to kind of put in a complaint. But if you've been using it a while, you're just as good without a state registration. And then there's service marks. And this is unregistered. Service marks are just for offering services. as opposed to goods. And once you have a registration of a service mark, it's the same circle R thing. So there's a lot that you can register. You can register colors. There's apparently an ironing board pad that's green that was really popular in dry cleaning. They got a trademark on the green. I used to do some work for ServPro. If you've seen their green and orange trucks, they've got color stuff going on. They also do it as part of logos and marks. That can be important if you become, somebody like John Deere, where you really think about that color, Caterpillar yellow, those sorts of things. And then it's important that you have, I know people want to do these things on their own, but they're not that expensive to have an attorney do, and it's a flat fee. And the reason that you want us to do it is it's very important at the beginning about when you're registering and how you're applying, because you can either do it because you're actually using it in commerce and submit the specimens. You can do an intent to use, but then you've got to get it in within 6 months or do these extensions up to 5 times. And then also, we think it's important to get an opinion. They're not that expensive. And an opinion is, we have searched and do not think that we have been able to find any marks. And we have much larger databases. Like, we don't just search the trademark office's website. You can do that yourself. And you should do that before you even go in to talk to an attorney, is make sure you're clear there. And here's the other reason. You need to understand that your specimen is actually a specimen that demonstrates use in commerce, because you got to mail that specimen in or send a picture of it. So this has got to be placed on goods, tags, or packaging and sold or transported in interstate commerce. And so it can't be just within a state, and just showing advertisements. You can't just send in a web page. That is not going to get you there. Maybe for services you can, because that's a little different. But for a product, you got to show it really being used on the product. And then this is the other big thing, is picking your classes. It costs money for every class you do. And you've got to be in certain classes. And they define you then define the goods and services within that class. So I was talking about the plumbing. That's class 37. And then you're going to say within that, it's plumbing contractor services or blah, 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 and be more specific. But it is important that you do this correctly. Because if you list a bunch, say a company comes out and they make a hat, they're we're going to get into shirts eventually. If they list hats and shirts, then it's really easy for someone to come along and get the shirts taken away and then start making the same shirt. And so it's very nuanced about how you do this. They are doing some new kind of autofill stuff at the patent office, because attorneys have been screwing it up. That actually the attorneys, to make sure that they get their goods and services the way that the trademark office likes them. But it's very important in evaluating which classes you want to be in. And so that's one thing that really, unless you do a lot of research, you're probably going to miss one or not get it there. And at least with us, usually if it's one mark, but you're going into multiple classes, it's not that much more to add on each class. All right. Oh, I had some examples. Oh, this was for Diatech, if anybody's familiar with Diatech diabetes. So you can see they have a class 9, a 42, and a 44, and they're kind of different descriptions. This is for the software. This is for software as a service applications, which is a different class. And then this is for remote monitoring, which is a totally different class. And so you want to get these things right early on. There's another thing called trade dress that's not registerable. And I didn't think it would really apply that much here, but it does, because I found this Inwood Labs case. This is not registered, but it's product packaging, design, color schemes, store layouts, and visual elements. The classic case for lawyers is called the Taco Cabana case, and it's about a taco restaurant and how it looked and everything. And some guy popped up down the street and it looked exactly the same. And they won, and they were you can't have it like that. Cracker Barrel, if you have in the front of your store a patio with rocking chairs, you better believe you're going to get a letter from Cracker Barrel about trade dress. They are masters, and they're just out here, their headquarters. They're really good at trademark and trade dress. And so this was the interesting example. They got it they were successful on stopping the generic from coming in and using the same coloration for dosages that indicated, and that was the dress of it was like, I know if it's this color combo, I've got the 200, and if I have that other color combo, it's the 400. Usually it's stuff like this. Payless Shoe Source is selling these shoes, and Adidas is like, come on. 2 stripes and 4 stripes. That's our shoe. You just differed the number of stripes. So
if I created a new color wheel, like you talked about earlier, can I apply that? It should be a little bit of a different color.
probably, yeah. Yeah. It's similar to the ordinary observer test I talked about before. So they're going to look at who's buying this or using it and think about, would they see a difference or not? Or would it be confusing? They're going to say, is it confusingly similar? Yes.
It's not registrable. What are the damages? And you send a letter and then.
So you don't go get a registration, but you have a cause of action to sue in court and say their damages are similar to what happens in trademark. So in trademark, you can be damaged like your actual damages, or there's some statutory damages where you say, I want this amount of money for this. But the registration, it's just, you can't point to a number that says, here's the trade dress. And so these are hard cases to win. Like, I was really surprised at that pill case, to be honest. Usually it's got to be like Coming to America when he's like sitting in the back with the McDonald's book and everything is McDonald's at McDowell's, right? But they tend to be something that people with a larger person with deep pockets as a plaintiff can go out and harass somebody. You see it a ton in franchise stuff where a franchisee breaks off and they're like, you didn't change it enough. I had a case against Shoney's and they were like, that U-shaped bar, they say that's their trade dress. And I was like, when I see a U-shaped buffet, that does not mean to me that I'm in a Shoney's. And it didn't work out well for them because, in fact, their flagship Shoney's out here in Donaldson, they took out the U bar, and their new ones, they're not even. So anyway, it's there, it exists. It's more of a way to stop people if you are really into your packaging. But we do have a lot of people that are selling things like on Amazon. So trade dress can be an avenue for them. And especially if you start to come up with if you grow big enough that you have multiple products and you're packaging them all kind of in a similar way. And everybody's like, I know that's that coming from that company. Not as applicable for life sciences, but I found one. Here are all the practical tips. I already kind of said them. Get a search and opinion before you file, so that you can make sure that you don't have to change your branding later. I didn't mention this. Go ahead and get your domain and your social media handles set up when you've decided on your trademark strategy, because there are these people out there that watch the trademark registrations and then buy the domains that match them and then squat on it and sell you back your domain. So I think one of the biggest things we saw was when the Redskins changed the Commanders, like, it was crazy. They kept it all under wraps, and then like 28 trademark filings all happened in one day, and all the websites got bought, and like they did it all in a coordinated way so they could make sure no one else would come in and try to capitalize on the name change. Periodically revisit your protections to make sure you've got the right classes and that your descriptions of goods and services shouldn't change. And then you've got to file these declarations to prevent abandonment. They're called the Section 8 and 15s. That's something like I was talking about, we docket, like it's years later. You're going to get an email from us like 6 months ahead and we'll be like, hey man, you still using this? Like, we got to file this Section 8 or we got to file this Section 15, and we'll remind you up to those dates. But if you don't do that, then they get abandoned. And when you look in the database, you'll see those as canceled. So they can get canceled other ways, but that's typically what you're seeing is people didn't file their Section 8 or 15 when you're looking at all the dead marks that exist. And then it's important to monitor others' use of similar marks, including their trademark applications, because if someone files, you may want to file an opposition. And that's a lot easier to win than it is to do a cancellation after they get a mark. And yes, they're examined, but sometimes, the examiner can't tell that it's close. You may have a whole line of products and they don't see that it's as close until you kind of look at the whole line of products. When you do one of these, you're actually involved in the opposition or the cancellation. We do these proceedings. and you have an attorney that's like on your behalf arguing why their mark should be canceled. All right. Oh, 5 minutes for copyrights. We're not going to hit AI. I'll hit it quick though. Copyrights, creative expressions fixed in a tangible medium. We're usually talking about art, literature, music, drama, and other works. These exist without registration, but you need registration to get remedies. So the moment I snap a picture on my phone, I have a copyright in that image, but I haven't registered it yet. If I want to sue someone because they use my picture, I got to have a registration. Also, it provides notice and helps with damages issues. This is like all the stuff in the law. Like I said, the registrations have some benefits. You have to have it to file suit. It gives you a presumption of validity. It expands your remedy fairly high. And then it provides notice to third parties, can help you a little bit if you ever have to deal with stuff internationally, because you can say, look, there was this notice out there. You can register these with customs if you want to stop imports that are coming in. And they're relatively inexpensive to register. We have seen people do it. We run out of time? No? Did my TV? Whatever. Software. Software is a literary work when fixed in a tangible medium of expression. Examples include source code, compiling as an executable. But remember, like I said, you can implement it in many ways when coding. So this is a reminder that if you're dealing with software, your business agreement should include a no reverse engineering clause. We usually put that in the non-disclosure agreement when it's appropriate and when software is involved. And registration is cheap. And this is one you can actually do without an attorney, although I'm happy to do it. And there are a couple ways, like magazines and stuff, you can do compilations, but for your code, you should be able to do that yourself. Now, I will say you have to disclaim any previous versions. So if you develop a new version of code, you want to copyright on registration. When you register it, the old ones go away. And this is not considered, software is not usually considered a work for hire. So you'll see this work for hire language that is getting co-opted from artistic contracts that just people put in because they either didn't want to pay a lawyer for their agreement, or their lawyer just is putting everything in. Software is not really a work made for hire, so you need to have specific language to address the ownership of the software.
So you're saying if you hire somebody to write code and you put the work for hire in there, they could still own the code?
Yeah, it's not considered the same as like every other artistic type thing. Then license issues, and this is a big thing to think about because a lot of people are using open source software. So open source software, if you don't know, it's publicly available source code that's licensed for use, modification, and distribution. There are different schemes. So you have permissive licenses like MIT, Apache, and this BSD that pretty much will let you make it proprietary if you modify it, and it's fine. You may have to give them an attribution. There's what's called a copyleft license. These are mainly the GNU licenses, and they can require that derivative works be open source under the same license. So you don't want to start with their code and develop yours, because then you have to license it out for free to anybody that wants it. And there's this AGPL is a GNU license for SaaS applications. So just think about where your starting point is and make sure you understand the licensing implications. So you don't want to contaminate your proprietary software with copyleft open source. And then you could have problems if you're combining stuff with incompatible licenses. So you just want to make sure on that. All right, I'm going to take up 3 more minutes of your time because AI is cool. Patent inventorship. AI is not an inventor. It cannot be an inventor. Whether a human using AI is an inventor depends. We do know for sure that it can't be. This guy Thaler, you're going to see his name a couple times. He loves to challenge patent office stuff. He created this AI Davis, and it came up with 2 inventions, and then he filed them on purpose, naming Davis as the inventor to test the system. There's lots of people that like to do this kind of thing. So you need some human involvement in the inventive process. Remember, conception. So using AI as a tool doesn't disqualify you, but it really depends on who conceived it. So did a human direct, refine, or validate the AI generated output? that can get you more into that land. We don't have any guideposts on this. This is the only real case that we've seen so far. And so I know we have no idea how it would come out outside of the US. Nobody's really addressed this yet because a lot of times people look to our patent laws first to kind of see what's going to happen. And that's from the last slide. So this is in the slide deck. This is specific USPTO guidance. You can look at this and think about it if you're doing these sorts of AI things. All right, copyright real quick. Only humans can be creators or authors. So Naruto v. Slater is really fun. This monkey took selfies, and then it wasn't PETA, but it's somebody like PETA sued on behalf of Naruto. And they said, no, he's not a person. Sorry. But the pictures are amazing. And then Thaler then made, he used, what was that thing called? He made his own called the Creativity Machine. And he made this called a recent entrance to paradise. Then he specifically identified in his registration application that AI was the sole creator and it was rejected because he's again testing the bounds. This is not completely true on copyright because the selection and arrangement of the AI generated content can render it copyrightable. And this image is not, because that was completely made by Midjourney, which is another one of these generators. But then all the selection of the Midjourney photos and arrangements in the comic book, that is copyrightable because that had enough human output over the creative work. It's hard to know how that goes in software, but there's creativity to coding. Everybody codes different. People say you can see who coded what if you really know how to look at those markers. So it's something to think about. So here's the practical tips on that. And I made it. So I'll take any questions and then we're going to have charcuterie and wine and beer and all sorts of stuff. Yep.
Question of reverse, where you've got an inventor who leaves the company and then the company does not put them on the patent. So what happens?
So if they're a proper inventor and you don't name them and the other side finds out about it, they can sue to invalidate your patent. Or they can have a claim for invalidation of the patent for incorrect inventorship. If you are in district court, there's still an opportunity to correct, but you might have some problems depending on, it all depends on what did you have contractually in place with that person, or are they willing to come and do the inventorship now? It's an interesting thing to think about because I had a case where we really needed a guy to sign something to do a reissue, and he died 2 weeks after he signed it, and we would have had a real problem because he had to swear there was a mistake in the patent, and if he hadn't made it, like, we had no idea. I got a little off of that, but yeah, so it does invalidate the patent. There are methods to correct it, but it really depends on what forum you're in as to whether you can go in and do that correction. Because you have to back it up that it was a mistake and not purposeful. And because if you then start to try to say it was a mistake and they find out it's purposeful, then that's fraud on the patent office, which is inequitable conduct, which renders your patent unenforceable. So there's a lot of problems there. So the biggest thing is get a employment agreement that says, I hereby assign all rights. That generally can be enough at the patent office to do what you need to do with inventorship, but you should get it right.
Like,
Yeah.
you still need, even if the person
You
signed all
want
rights,
their name on the, yes. Yeah. So, I mean, most of the time you just cut off any rights they would have by having them commit to assign it.
Yeah.
Yep. It depends. And they're litigating this real heavily right now. I think Meta's been sued. It's become clear they were going behind paywalls and taking copyrighted material behind paywalls and using it to train. So we will see how that works out. There's some artists that have filed some lawsuits that it hasn't gone that well, but they don't have the war chests to fight it like some of these other people. So I don't know. What I would say, because I like to philosophize on these things, is if we're not careful, all the content on the internet's going to be AI generated in 5 to 10 years anyway. So there won't be any original human content that's copyrightable for it to scrape. The Ouroboros of the AI, right? Like,
Snake eats its
yeah,
tail.
yeah.
Yeah.
So I don't know. We'll see. But like the internet's getting dumber, right? And that's the reason. All right. Well, thanks everybody. And if you need anything, just shoot an email with me.
Appreciate it. Thanks a lot, Seth.
I do. Everybody's gonna see. No, they're not.
So glad you're all here. I'm Abby Trotter. I'm the Executive Director of Life Science Tennessee and the Life Science Tennessee Foundation. Carrie has done a terrific job with the Life Science Tennessee Foundation, getting our new or revamped mentor network, which is now our Life Science Mentor Program, up and running. And this is our first of our education series. I'm sure she told you all that at the beginning. We have several things coming up for Life Science Tennessee as well. So maybe we can pull up this PowerPoint that I just emailed Seth, but if not, it's okay. Just but a couple things that I wanted to make sure you all knew about. The big one is our Day on the Hill, which is going to be on February 26th. That is a day where we'll be gathering downtown, inside the Capitol, meeting with legislators, talking to them about the importance of innovation, the importance of research, and the importance of new technologies and new startups that are coming in the life sciences and in other parallel technology industries around the state. Actually, it's a very exciting year this year because the governor has announced just last night $63 million for innovation in the state of Tennessee. It's the biggest amount the state has ever put, or any governor has ever proposed, to build Tennessee's innovation ecosystem. But there's a big but. We have to get it across the finish line. And there's a whole lot of horse trading for those of you that know anything about the legislative process. There's a whole lot of horse trading that goes on over the next 4 months inside the General Assembly. And we've got to make sure that we demonstrate to them the impact of a program like this. So if you'll, that first one, that's our Day on the Hill, that next slide. So I invite you all to go on our website and register for our Day on the Hill. And you can tell them about the technologies and the importance of the technologies and the startups that you're doing in the state of Tennessee. And then finally, just a little overview about all of our programs that we have going on. This is our Day on the Hill that we just talked about. Well, this one we've changed. Yeah, we're changing this one to later on in March. So stay tuned on that. So these are different events that we have coming up, breakfasts that we do inside Nashville to build the ecosystem. The Bio Trade Conference, we're doing a big booth at Bio this year, which is in Boston. This is the other date for our ecosystem building breakfast. LSTCon is going to be on November 18th this year, which will be great. And obviously the second Tuesday of every month, we'll be doing this Life Science Venture Program education series, followed by a little bit of a networking time as well. So these are some events that we have going on. The best thing to do is look at our website, check out our social media, because we'll be sure to update everyone on all these events. But Seth, always the great expert on patents.
I don't know about that.
All that. So we appreciate your time. And thank you so much for coming in. And thanks, Carrie.
I think you covered everything I was going to say too.
Oh, okay. All right.
Thank you, Seth, and thank you to Patterson for hosting. And yeah, well, I guess the only thing is to add on the second Tuesday of every month is when we'll do these sessions. Next month, March 11th, we're going to be taking the show over to Memphis, and Epicenter will be hosting us over there. But again, it'll be live stream so that anybody that wants to join virtually can. But it will be.
And next month's topic is
focused on customer discovery and using that to influence and inform your decision making.
So if that didn't get picked up for the internet audience, it's going to Memphis, what, March 11th?
Yes. Memphis
At Epicenter, and it's customer discovery,
yes.
Right? Thanks, everybody.
You-